Hey, right,
Hello.
guys. Welcome,
Hello.
everyone. Um, Welcome to this week's live stream. Blah, blah, blah. You know the score. If you want to put questions into the live chat, please do so, but please don't include personal data. So just ask the questions as if they're about someone else, so you don't have to disclose anything. We've got about 6 or 7 questions that have come in during the week, so we've definitely got some stuff to get on with. But yeah, what else I want to say? I felt like there was an announcement to say, but I can't remember what it was. Oh, that's it. Yeah. So keep the 7th of March in your diaries because we're going to run a free event. It's actually in this slot. It's on a Thursday evening again, looking at local democracy and ending homelessness. So we've got so a guy down from Brighton who's going to be kind of on the panel. So he's kind of going to be talking about his experience of going to housing committees. He's been homeless himself, and has done a lot of stuff for a lot of years in Brighton in terms of just kind of raising issues, and I think he's had a lot of success there. So he's got a YouTube channel as well, which I think is housing and homelessness in Brighton and Hove. But I'm going to check the name of that in a minute, just so if you want to go and check it out, that'd be cool. Shannon's going to be on it. We've got the local democracy reporter from Bedford Borough, and we've got a local councillor from Bedford Borough Council, and we've got Will Moy who set up Full Fact. So there'll be 6 of us. So yeah, do keep an eye out for that. As I say, it's in like I don't know 9 weeks time or something like that, 8 weeks time. But should be very interesting for anyone who wants to actually do anything useful in terms of political stuff locally, because it's a very effective way of getting things done. Other than that, I think that's all the announcements I've got to go through. So that will do for time. Let's get into it. So the first question, if we can go to, is one that came in the week. So basically, this person has been homeless. They're sofa surfing for 2 months. They say they're very high priority. They've got mental health issues and they're autistic, but they've essentially been abandoned by their social worker and can't contact them, and have been offered no other help and asked what should they do. So there's a few kind of things I guess just we can kind of sketch out here. So guys, just do chip in um, as and when. But I think the first thing that I'd want to know in the situation is in this person's area, what kind of council is it? Is it a unitary authority where there's only one council that kind of covers the whole district? Or is it a two-tier local authority where you have a social service authority and a housing authority, and they're two different ones? So you might have, like, for example, um, I don't know, Suffolk County Council, which has got social services, and then you've got East Suffolk Council, which is like a district housing council. And it kind of makes a difference because if you're under social services in one local authority and you're going to housing in another local authority, it just means they're slightly less cooperative with each other. They don't like each other anyway, generally, even in unitary authorities. But it's just something to bear in mind that kind of gives a bit of context to the answer of this question. So um, there's a few ways of doing this. If this person's able to, they should make a homeless application basically to their local authority, in writing via email saying, "Hi, I'm Joe Blogs. I'm currently sofa surfing, and I've got autism and diagnosis of other mental health issues. Can you help me with housing?" And that immediately should get someone kind of responding to you. There is reason, I would say there's clear reason to believe this person might be in priority need. So assuming they are a British national who've got settled status or whatever, so they've got recourse to public funds, or if there's reason to believe that, and there's reason to believe they might be homeless, then the council owes them an interim housing duty under Section 188. So that's our starting point. Guys, do you want to chip in? So it's not, I appreciate last week I was just doing a lot of talking, so I'm going to try not to do that this week. So if anyone wants to kind of go on where I've left off, if not, I'll keep going.
I was just going to add as well, it's probably worth trying to get in contact with social services. But if you're really getting no sort of answer from your social worker, there's nothing stopping you complaining. Or even I've had some luck previously with housing, just emailing the generic email address, the sort of the standard go-to social services email, and going, "Oh, I've been trying to get hold of my social worker, such and such. This is my situation. Explain why you need that contact." And often, because it can be a different person that answers those emails, they can sort of get you through straight away. But compiling your own paperwork, so getting a list of all the letters together that your social worker might have done for you, getting diagnoses letters, all of these things, the paperwork side of things is stuff that you could be getting on with whilst making the homelessness application in the meantime.
Yeah. So I remember seeing when we've kind of requested records for people before, you kind of, what you see in these email exchanges is where like the duty person is basically sending frustrated emails to the housing officer saying another one of your clients is come to us because you're not responding to their email. So you kind of see that going on in the back office. So yeah, Shannon says you emailed a colleague and say, my social worker is this person, they're not responding. I need this immediate support now. As a way of doing it. Will, do you add anything at this point?
No, I think Shannon and you have hit it. I mean, that the key point being most local authorities have complaints sections on their websites. If you just do a Google search for the name of the council and the word complaints, you'll normally land on it. And it's either done through one of those online forms or an email address. And once you get that in there and just keep following it up, it tends to result in getting a response. One thing to say is, with the social worker abandoning the person, it may be that the social worker has simply left because they have a very high turnover of staff in social services. And it may be that they left, they never told anyone that they were going to leave, and the file is, your case, as it were, is in a queue waiting for somebody to take it. And it may be that you'll find that's what's happened. I mean, it's unusual for them just to completely go to sleep while they're there, but it's not unheard of.
It's
It
not.
might also be worth, because I think there's a misconception that a lot of people understand autism. But with regards to your housing anyway, it's probably worth not just saying, you've got autism, but saying that these are what I need because of this. I need this sort of accommodation. It needs to look like this. And, your mental health can be included in that as well. But really like laying it out black and white, all in writing, because yeah, some people's understanding still won't actually know what that means for you.
Yeah, and so you might add in a point saying, I need to be, and I need to be corresponded with via in writing rather than verbally. Because I struggle to take information on in a verbal meeting. You might be say, you're going to struggle with the kind of the interview setup itself. So you might just need talking through that before you get there. All of those are kind of reasonable requests. On Will's point, like so, we often talk about complaining to the chief exec. As an alternative to going through the council's complaints process. Now, if you just Google your council's name and say, ask Google who's Bedford Borough Council's chief executive officer at the moment, you'll get the name of that person, and all you need to do is just put their name into the standard email sort of setup. So joe.blogs@bedford.gov.uk would get you the chief executive, that's their name. And that is a good way of just kind of putting the issue outside of the housing team, particularly where you've got an issue where it sounds like social services may well have been failing here as well. I mean, it's I mentioned at the start, these kind of two-tier councils, but for a unitary authority, which I think, or certainly a lot of councils are moving in that direction, you would potentially have actually triggered a homeless application by telling your social worker that you're homeless and need help with housing, because the housing or the homelessness code of guidance is very clear that you can make a homeless application to any department of the local authority, and it can be expressed in any particular forms. That's 18.5 or 18.6, the homelessness code of guidance. So it's very basic stuff. It should be done. And also, equally, housing officers have duties under the Care Act if they have reason to believe that person might have care and support needs and needs an assessment. So it's kind of, there's a lot of law out there to help you. It's just a case of basically, banging the drum a bit and kind of just pushing the relevant people. If you really want to go belt and braces, you can just copy in the local councillor of adult services and housing. So that could be two people plus your local councillor, as a way of just kind of, putting it, up the list of urgency that the council actually responds to you. So yeah, I mean, and I guess just in terms of sofa surfing, just to state the obvious, you're homeless if you're sofa surfing. So it's not like, the council can't say, oh, you've got somewhere, you're not homeless. Assuming you're staying with a friend or something, and it's an insecure basis, then you are homeless. So so the council's duty to provide interim accommodation is immediate. Now you might say, well, actually, I'm okay at my friends for the time being. That's a legitimate thing to say. But generally, by doing that, you decrease the urgency again of your case, so you end up kind of going back to the bottom of the pile because you're not costing the council money. So it's a difficult situation for a lot of people. Is do they stay in a kind of a relatively or a better sort of setup with a friend or family member in the short or medium term? But the downside is, and you won't get told this, is that means that because you're not in temporary accommodation, you're not necessarily on anyone's radar. So they'll just kind of let you just sit there. They don't care if you're, they'll kind of hope you go away basically and sort yourself out. So so that's just something to kind of weigh up as well with it all. So hopefully that's kind of answers a few questions there. You're right, Andrew. You're right, Nick. Nice to have you here. Any other regulars, please do shout. It'd be good to hear from you. So next question was, do local councillors and local MPs have a lot of power with respect to homeless applications? That's a really interesting question. The answer is potentially yes. So a little bit about the structure. So MPs aren't kind of affiliated to a local authority, and in fact, you'll often have MPs who straddle two different local authority areas. So, for example, Bedford Borough has got Mohammed Yazin, who kind of covers one bit, and then I've forgotten his name now, Richard Fuller, who covers Bedford Borough and a bit of Central Beds as well. So he's straddling two areas. So that's just one example of many. So they don't have any kind of direct authority. They can't tell the council to do anything, but they do still hold a fair amount of weight, particularly if it's a sensible issue. So recently in Bedford, as an example, so John Allen over at Just Us was raising this issue of the Travelodge having a policy where, ordinary guests can have a dog, but if you're homeless, you can't have a dog. And John said that's not on. So he complained to the Travelodge's chief exec and went to the MP, and the MP appears to have actually, that's Mohammed Yazin. He appears to have kind of actually done some work on it. And as far as I know, they've just changed the policy so that the Travelodge will accept families with dogs or people with dogs in Bedford Borough. I don't know if it's wider than Bedford Borough, but certainly in Bedford Borough. So that's an example of where an MP can be helpful. You might also have a Nadine Dorries, who's our neighbouring area, who never turned up to surgeries as far as I know and was useless. So you might get a rubbish MP. So that's MPs, and then with councillors, they are part of the council, so they do have more authority. Again, it's going to depend on, are they in the ruling party? So in Bedford we've got a pretty even split between Conservatives, Labour, and Lib Dems. And there's a couple, I think 3 Green councillors as well, and a couple of independents. So in one sense, if at the moment it's Conservative are in power effectively, so a Conservative councillor would have more clout than a Labour councillor would at the moment, or a Lib Dem, but it obviously does fluctuate. And again, sorry to keep going on about this, but you have different kind of portfolios within that council. So you have like a planning portfolio, a finance, a housing, a social care, children's social services as well, probably some others as well, and there'll be like a lead councillor for each of those areas. So you'll have a councillor who's basically overseeing the housing and homelessness side of things. Some councils, it might be 2 people because sometimes it's under adult social care as well. It gets all divided up weirdly, but so they would also be a natural person you want to involve. And you can go on your council's website and there'll be like a Find My Councillor tab. You click in your address, you'll find your local ward councillor, but you'll also have a list of councillors and what they cover. So you might, as I say, be able to kind of email more than one person. And some areas will have two councillors anyway. So yeah. So there's more probably to say about that, but that's all I'm going to say for the time being. So guys, anything you want to add to that at all?
Not really.
No. Cool. If I was homeless, I'd copy my counsellor and any other relevant counsellor every time. I would, they can't stop you doing it, and it just makes sure that the housing department will realise that they're going to be held accountable, so they are more likely to follow the law. So yeah, it certainly does help like that. So next question. This right. I'm just thinking about. I'm looking at the question 4 I sent over, guys. It's just, there's various bits to this, and I don't know. So I'll read it out so we know what we're talking about here. So it sounds like councils have to look at universal credit to assess affordability. So this is someone who's watched the video we did about affordability, but you didn't explicitly state how so. So as in how councils have to look at universal credit. It'd be good to know more about this. And then, so there's 3 questions in one, so I'm going to leave it there. So the question is essentially, in the video that we did about affordability, I think it was a video you and me did, Will, we basically said, if you can't afford your home, you're legally homeless. And then we went into a bit of detail about what the definition is legally about whether your accommodation is affordable or not. And unhelpfully, the law changed. Well, there's a new case, the Baptiste case, because the previous case law, which was Supreme Court, which was Samuels v Birmingham, was really crystal clear. It basically said, when DWP calculate how much money to give you, they only give you enough to cover your, kind of essential living costs. Basically, it specifically doesn't cover housing. So if you have someone who is having to top up their rent out of that element of their universal credit towards their housing element, then they're automatically considered to be in unaffordable accommodation. Now, the Baptiste case, in my mind, just made it. I don't know what it was really saying. I don't know if it was actually saying anything different from the Samuels case, really, but it was kind of, I don't know, kind of just being even more vague. So it kind of said, I think it was basically saying even the DWP kind of approach of like looking at what they give is actually still not kind of kind of doesn't kind of apply to every situation. So yeah, I mean, maybe it might be. I probably need to read that Baptiste case again. It was Baptiste v Kingston. If you want to have a look at it, if you Google Baptiste, so it's BAPTIE v Kingston, you'll get a number of kind of kind of summaries and kind of analyses of that case. But I've read the case in full. You can, I mean, a great resource, I probably have mentioned it before, is the bailey.org. So it's British and Irish legal something. So BAILII.org. And that hasn't got every case that's ever happened in it, but it's got transcripts of any significant case, and you can get like literally the full judgment, which is a really good way of getting into the meat of it. It's not easy reading, but it's a really good way to see how these different kind of principles all work in practice. So I don't know, have you guys got a better answer than I have on that one in terms of, how? So I mean, there's a difficult. Let me go. I do know a little bit more actually about this. So for a long time, councils have used research from different organisations. So AHAS did do the research on affordability. So AHAS supposedly sat down and worked out how much it actually cost to feed a person for a week. And that, the last time we heard it was £28 a week. So they kind of had these set amounts, and the local authority would use them often, kind of, flexibly when it suited them. And essentially they would kind of say, well, you spent 20 quid this week on clothes and you should only have spent £4 a week on clothes or something like that. So they would use it. They'd be very difficult with it. But that approach, as far as I know, is not legal. But since then, AHAS no longer exists, and Housing Reviews Limited is doing that research, which in my opinion is very troubling in terms of my experience of housing reviews in cases like this. But basically, so councils, whether or not they should do it, they almost certainly will refer to that research, and they'll kind of say, well, you spent 50p more than you should have that week, so it's your own fault, and we're going to find you intentionally homeless. And just to make it clear as well, the definition is the same whether you're applying it to whether you're homeless in the first place or whether you're intentionally homeless. So it's impossible to be intentionally homeless from accommodation that you could not afford. So even if you smacked your landlord in the mouth and got evicted for it, you're still not intentionally homeless if that was not affordable rent. So yeah, it's just, I guess, yeah, that's as far as I can get you on this question. As I say, it might be something worth we just kind of return to in a more organised fashion in future, and just kind of look at the Baptiste case and see what it actually was saying. I have read it a few times, but I was like, I don't know what the point is here. But anyway, so yeah, unless we've got more to say on that one, we'll move on.
I would say that just to add that the Samuels case did represent a big change and also a shift in policy, because the courts were aware that before Samuels there was this awful business. If you lost your home due to rent arrears, or then you get into this thing where the reviewing officer would say, well, if you cut this or that, and I think you could live on sort of rice every day or something. And it would vary from council to council, because you could get some hardliner in council A, and then 200 miles away you've got somebody reasonable. So the problem was there was no objective test. It just came down to what these individuals thought. So Samuels was saying, if I'm not mistaken, that you've got to have an idea of reasonable living expenses, and you can't just start saying, well, I think you don't have to spend all of your universal credit. And I'm not sure if it was in Samuels, but the general proposition now is that universal credit is calculated to provide subsistence. It isn't provided to pay. It's not calculated by the DWP to say, well, here's a budget. You know, if you've got some other things you need to spend, like pay some extra rent, you can do it. So I'd have thought that if you're spending on something unreasonable, you may be at risk. But as long as you're not doing that, then it should be possible to say that you can't be expected to use your benefits to pay shortfalls in the rent. But yeah, maybe we should have another look at that Bapty case, because that tends to sort of go back on it, doesn't it? That the reviewing officer
I
basically
thought it
did the
was
same old trick.
Yeah, it was very unhelpful in my opinion. I mean, I mentioned housing reviews limit. I'll kind of give some brief bits about the case I'm thinking about when I talk about this. So this was a few years ago now. So this guy, long-term rough sleeper, he got put into unaffordable private rented accommodation by the council. He then lost it, and was then back in making homes application. He was in priority needs. And the council were now trying to say he was intentionally homeless, because I can't remember what the reason for his losing the flat was, but it was, my argument was it wasn't affordable. And so Gabe submitted the figures using the AHAS research, which was the approach at the time. The council then passed it on to Housing Reviews Limited. And it must have gone back between us like sort of 2 or 3 or 4 times, where every time I would say, well, hang on a minute, this guy's got DVTs in both legs, he's got regular hospital appointments, he's got doctor's appointments he's got to get to, he needs to pay for that. Every time I kind of submitted more robust information, they would kind of say, okay, well, yeah, we'll take that, but now we're going to actually take another £10 off a week for food because, we can. And so it ended up going back to Bedford Borough Council, and the review officer at Bedford Borough Council said, yeah, no, we're not going to go with housing reviews here. We're just going to make our own decision because this guy clearly wasn't able to afford his property. So he wasn't intentionally homeless. He's since been housed. It was before COVID. So maybe 2019 is still housed. So long-term rough sleeper, supposed to be unhousable. Actually turns out he can be housed as long as you put him somewhere suitable. So that's my experience with them. And they often, well, they come under some criticism from judges in various cases I'm aware of as well. So yeah. Let's do a proper job on this one, because it's obviously an important one. So that was the element of the question which was talking about affordability, which I'm not sure really further forward with in terms of hard and fast stuff. But as Will says, as long as there's nothing stupid in your spending, then you're probably okay. If you're most people who are struggling to get by, you're probably going to be okay. That's one of the reasons why they actually request your bank statements, because they'll go through it and they'll say, oh, what was this Amazon payment for? £20, or they'll kind of go through it like that. It's quite an unpleasant experience, but it is what it is. So that's they are able to do that. I've even seen housing officers will also jump on your Facebook, anything that's publicly available about you, and they'll see what you've been up to. So if you've got holiday pics from last week or something, then they'll say, well, hang on a minute, you've been on holiday, you could have afforded the rent. So that's the first element of the question. The second element of the question, I think, is actually simpler than it seems. So does the same guidance as in what we just talked about apply if someone is in affordable housing but has been sent a Section 21 from a private landlord, and during the time they live in the property, rents have increased by £200 to £300, and therefore the tenant cannot afford to rent another property? I'm wondering whether the council can help with that. So in one sense, there's actually a fairly simple answer. So in one sense, it doesn't matter that the rents increase and properties are no longer affordable. You're just looking at it at the moment in time. So if you've been given a Section 21 notice and it's valid and it's going to go through, so you're going to be homeless at some point, you need to make a homeless application, and whatever the reason is for you losing that property will be taken into account. But it's then on the council to find you suitable accommodation, which includes the idea that it has to be affordable. So the fact that rents are now £200 or £300, more than they used to be, and you almost always over what Universal Credit will pay, is the council's problem. Councils haven't built enough houses, which is why rents are so high. They need to fix it. So if they've got a duty to house you, they have to house you in affordable housing. I remember another case when I worked with a lady who's single mum. She had I can't remember how many children, but basically she'd been put in private rented accommodation under the main housing duty, so it was a private sector discharge. And when we looked at the numbers, it wasn't affordable. So we went back to the council and they said, yeah, fair enough, we'll re-accept the main housing duty and we'll find you somewhere else. So that's an example of how councils can't house you somewhere which is not affordable. So in that situation, you'd make the homeless application, it would proceed as normal, and then at the end of it, if the council do owe you the main housing duty, it's going to be in social housing or affordable private rented, or they're going to have some sort of payment arrangement to top up your rent, which is unlikely because it would have to be long term. Indeed, discretionary housing payments, so DHPs, only usually last for 3 months at a time. They can do repeat ones, but it's laborious and stressful. And then the final question, which we will not talk about in too much detail because we've done it several times before.
Just before we move on to the final one, sorry, because I'm just thinking, although it's not relevant to their homelessness, potentially that is an opportunity to mention the fact that the rent's gone up during that period, because the council might then be able to do a discretionary housing payment whilst the Section 21 is going through and all that process is happening. So, because I'm just thinking like how stressful it would be. You don't want to get into a situation when you then end up in arrears in that last little bit because the landlord's up the rent as well as the Section 21. Like, it sounds like the landlord's wanting them out, in which case it's definitely worth mentioning to the council, because they'd potentially either offer you, like you say, affordable TA, or a DHP for that place. That was the only thing but I couldn't work out how it was in my brain. Sorry, I was slow on that.
Well, so the way I read it was, in one sense, that their rent is affordable, but so when they moved in however many years ago, the rent was £600 a month, and that was the market rate. But now the market rate for a 2-bed or whatever is now £900 a month. So they've not been able to find somewhere else. I think that's what they're saying. But obviously when you go to a council, you want to give all the details you possibly can do to make sure you're getting the right help. And then the final bit is just about this question of, do I need to, can the council basically tell me to wait until the bailiff comes knocking? And the answer is no, they can't, or no, they shouldn't. But in the real world, I remember Will saying this back in September or so, actually in the real world, you can't really challenge it, because by the time the challenge is successful, the bailiff state would have come anyway. So in one sense, as soon as the notice has expired, the Section 21 notice has expired, the council should be looking to place you in temporary accommodation unless some of the exemptions apply. For example, where there's a realistic prospect that they might be able to negotiate with the landlord to actually keep you. So if you look in Chapter 6 of the Code of Guidance, I'll find the paragraph numbers in a minute. There's about 5 or 6 paragraphs which are well worth checking out, that kind of give a bit of detail on what the council should do. But as Will said, that might be great on paper, but if you complain about it, or if you get a solicitor, by the time it all goes through, it wouldn't make a difference anyway. So you can complain about it, but for all intents and purposes, there's not a lot you can actually do about councils telling you to stick around. Again, just to keep using Bedford as an example, because that's where most of my casework's been. I believe they got to a point where they were telling people, look, we have a duty to put you in temporary accommodation now, but we'd rather you waited until the bailiff came, and we'll pay your court costs, because if you wait that long, potentially you could be liable for court costs, which is, I think, something like £300. But what Bedford Borough Council was saying is, look, it's actually cheaper for us to pay those court costs than it is to put you in temporary accommodation for a couple of months. And for a lot of people, they much rather stay in their own accommodation, even though they're about to lose it, than go into temporary accommodation. So in some situations, that works for everyone. But the council can't tell you that we don't have a duty to house you until the bailiff actually comes. It's kind of there's more to it than that. I'm just trying to find the paragraph now. So it's all around paragraph 6.35 of the Code of Guidance. So I'll read this bit out. So the Secretary of State considers that where an applicant is an assured short-hold tenant who's received a valid notice in accordance with Section 21 of the Housing Act 1998, and the housing authority is satisfied the landlord intends to seek possession and further efforts, blah, 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 haven't been successful, and there'll be no defence, then it is unlikely to be reasonable for the applicant to continue to occupy beyond the expiry of a valid Section 21 notice, unless the housing authority has taken steps to persuade the landlord to allow the tenant to continue to occupy. So again, read it for yourself, Google Homelessness Code of Guidance, paragraph 6.35, but look in that section, because it's not, it's a little bit, it almost kind of contradicts itself slightly. So just do read it and kind of just take in the nuances of it. But yeah, so as I say, we've tackled that question at length on a couple of other videos, so I don't want to do it again. So we've got some questions on the live stream. First question: how do I find who is the MP of Hounslow homelessness? Okay, so a little bit of, I think we just need to kind of clear up the terms here. So your MP is your member of parliament. So if you Google MP of Hounslow, even if Hounslow isn't actually a constituency, you'll still get the MP. So I'm going to do it now. MP
So
for
I did it. Here we were earlier. So there's two apparently. Brentford and is Isleworth is Ruth
Isleworth, yeah.
Cadbury, and Feltham and Heston is Seema Malhotra.
Yeah,
But
so
yeah, I don't know if MP is what they were after.
Yeah, so I think what you're after is the councillor who is in charge of yeah, the kind of the homelessness portfolio. So again, I'm going to do it just whilst we're talking. So all I'm googling is Hounslow councillor portfolio, if I can spell, of housing. And so I've got, so cabinet portfolios has popped up, and then we've got to work out which one is likely to have housing as part of it. So this is where it might be in, for example, it might be in the environment strategy, or it might be in planning. Might be in the kind of trying to think what it could be in. Whilst we're talking, I'll find it. Basically, there's loads. It turns out there's loads of portfolios there.
I've seen they've got a housing and environment scrutiny panel.
Yeah.
And there are 1, 2, 3. So you've got Councillor Madhida Asim, Councillor Ghazala Bhatt, Councillor Jack Emsley, Councillor Richard Foot, Councillor Samina Nagra, Councillor Marina Sharma, and the chair is Councillor Mohammed Umar.
So the chair is probably the person they want.
Yeah, this does kind of look, it might be out of date though. Their website's quite difficult to navigate, actually.
Yeah.
But you can also email the council's like generic customer service email and ask and say, look, who's the councillor that deals with housing? And they'll likely respond and say, look, here it is, or they'll give you a link to the answer.
So I'm just on Hounslow's site. It says Councillor Sue Sampson is cabinet member for housing management and homelessness. So I think Sue Sampson on the site I'm looking at is the one you want. But again, as Shannon says, it might be that this information is not in date. I mean, it's rather important that it is in date. So my guess is they probably have got it up to date somewhere. Anyway, so that's just an example. As I say, we went through it just for Hounslow, but you can do that in any area. And it's, as I say, it's only a few clicks to find actually the person you want. So next question in the live stream, in the live chat. Someone's in relief duty. 56 days are up in 7 days. They're in temporary accommodation at the moment. They had to sell their house due to proceeds of Crime Act because it was made an asset. Will I get the main housing duty? Okay, so interesting one. I don't know a lot about the Proceeds of Crime Act, but I guess the question is the important thing to say is that what the council looks at, it's like a 6-part test they look at with intentionality. So the first job is to find out, is to find out where your last settled accommodation was. So what address that was, because lots of accommodation types aren't actually settled, but they look back. So if you own the house, yeah, that probably was your settled accommodation, unless you had somewhere else to live or something, and that's where you're living or something like that. The next question they look at is, essentially why did you lose it? So in this case, if the reason you lost it was that because you had to sell it to give the proceeds to the police or whatever, however it works, then the council's next question would say, okay, well, why did you have to do that? And as I say, I don't know if it's possible to kind of have to do that because of a family member's behavior or something, or criminality, I don't know. But if it was your criminal conduct that led to all that, then you're going to be intentionally homeless, because at the point of committing a crime, you would have known that you could have been caught. And even if you didn't know the ins and outs of the police, the kind of the Proceeds of Crime Act, it would have been foreseeable for you that you could have you could have lost your accommodation because of it, and therefore you would be intentionally homeless. As I say, I've not seen a situation like this before, but I've certainly worked with quite a few people who become homeless because of criminality. They go into custody for more than 12 months or whatever. There needs to be kind of there are some kind of still some like little nuances that might mean you're not. So again, you have to kind of show maybe I don't know. I think I don't know enough about the way this would work to really kind of give any answers on that. I don't know if you guys know anything more than I do about this kind of situation.
Can I just take a little guess on this and maybe say something that might throw out a bit of hope? And I don't know much about the pros. Sorry, sound that doorbell. Hang on. It won't happen again. I don't know much about the Proceeds of Crime Act, but I'm guessing that what happened, the reason that the house has been made an asset is because it was bought with money that was obtained through crime, and therefore they follow the money and they say the house is an asset for the purposes of saying, well, we'll get the house because that's where you put the money that you got. That raises an interesting question, that if you got the house because of the crime, it's because I'm looking at the test of whether you lose the house because of the crime, but in this case you obtained the house because of the crime, and so it's difficult to see how you could both obtain it and lose it as a result of the crime. So it might be worth arguing that I didn't lose the home because of the crime, and that the crime had already happened before I obtained the home, and therefore it hasn't followed as it couldn't be seen as a direct result of that. But
so they've just had more information saying it was their crime that was done 13 years ago, but they only bought the house 4 years ago.
that's what I'm
It
thinking.
was my home that I was living in, and the house was given to me by my grandfather. So
Hang on a
if
sec.
it was given to you,
You wouldn't have had to buy it.
well, maybe I guess you buy it off of a family member. But I don't know anything about the Proceeds of Crime Act, so I'm lost on this one.
So my hunch would be, and I'm going to look in. I've got Jan Lever's textbook because I'm in business. I'm going to look at the way he breaks down the concept of intentional homelessness, but I'm not going to be able to do it right now. So I suggest we go through a different question, and I'll frantically try and find the answer whilst we do it. Shannon, would you be able to pick up on that comment that cut the next question that's coming? Basically, I think it's from the person who's in Hounslow.
So the next one then is, I'm a single parent, 3 dependent children, all under 15 years. You've got a dependent mother who's 80 years old and private renting. Landlord issued Section 21 and told to vacate on the 12th of March. Currently Band 2 priority. So I'd imagine that's the highest you can be, like being recognised as homeless. Band 1's normally for emergency domestic abuse. And then the follow-up, can the council make me wait through the bailiff's process? So we sort of talked about this in regards to Section 21. They don't have to. So it's in the Code of Guidance, and I can't remember the paragraph number now, but we did read it out about 5 minutes ago if you want to scooch back. But they can't make you wait through the process. At the same time, the local authority can arrange, if you like, sometimes it's easier, and essentially the local authority might offer to pay the bailiff's fees to help with that cost if you do want to stay there, but you don't have to. You would be in priority need because you've got dependent children and a dependent mother. Obviously as well, if you want her included in your household, make that known. Unless she wants to be housed separately, but it sounds like you want to be housed together. Yeah, have I missed anything? No? So the next one on the live chat is, do Cardinal Hume Centre help with housing issues? And I'm not going to lie, but I've not heard of them. Will, you're nodding.
I think they're Westminster, aren't they?
You're on mute, Will.
You're on mute, Will.
I was worried about that doorbell going off again. I've actually been to the Cardinal Hume Centre, and I can confirm that they do housing. And I've just checked with their website, and it includes the line, "Our expert team may be able to help you with your housing problems." So, yes, and if you Google Cardinal Hume Centre and homelessness, like I just did, if you're interested in following that up, that's what you'll find, and there's all the contact details on there.
So can we
Perfect.
return to this question of intentional homelessness because of the sale of the property? So this is from Jan Luber's textbook. I'm assuming this is legal to do. I'm gonna just flash that up. You could pause that and just read that bit there that's got the 6-part bit to it. So for those who want to like look back at this, but basically, so there's six tests of this intentional homelessness. So first thing, was there a deliberate act or omission? That's number one. And in this case, I would say that the council is going to argue that the committing the crime 13 years ago was a deliberate act. Number two, was that deliberate act or omission by the applicant? So as in by the homeless person. Now, this opens up the possibility that if you have a family member who was not part of that crime 13 years ago and you're now living with them, they could apply, they could make a homeless application in their name with you on the application as part of their household. Like the way the law works is there's no such thing as an intentionally homeless family. It's only individual. So if you have a spouse or if you have someone else you're living with, potentially that is an avenue that you could explore. Was the consequence of that deliberate act or omission that the applicant ceased to occupy accommodation? Now, I say yes to that because the deliberate act was the commission of the crime. That has now essentially led to you becoming homeless, so that would be satisfied. Then there's a fourth one is the deliberate act and the cessation of occupation. It caused an operative cause of the present homelessness. That means did it cause you? Yeah, is that the thing that made you homeless? The answer is yes. And then there's basically two potential kind of defences, if that's the right word. So was the accommodation available for the applicant's occupation when you lost it? And that's probably going to be yes in this this circumstance. I can't see how that would kick in. But the sixth one might kick in. Would it have been reasonable for the applicant to continue to occupy the accommodation? Now, this might seem like I don't know if it's going to be very relevant, but for example, if you were subject to abuse in that home, then you couldn't be intentionally homeless. If the mortgage costs or something were not affordable, then again you kind of come back to this idea that if it's unreasonable to continue to occupy, you can't be found intentionally homeless. So I don't think they're going to be particularly helpful, but they are there for that it's possible that might kick in. So the question would really be is, what does an intentionally homeless person do? And how do you stop being intentionally homeless, which are actually two questions which I think we haven't focused on as much before, so it might be good to look at them. So if you are intentionally homeless and there are no children in your household, as in dependent children, then so even if you're in priority need, the council will only have to house you for about 3 months or so. So the relief period, we're assuming here that you're in priority need. So they have to house you for the relief period in interim accommodation. They then issue their intentional homelessness decision, and you then have usually something like 4 weeks, depends on the local authority and how they're feeling that day, before you have to leave that temporary accommodation. The council should be looking at other options. So they should be saying, well, do you know what, we're going to find you intentionally homeless, but there are some supported accommodation that might be helpful for you. There's these options here, here, and here. You'd be in your interest to apply to them now to get on the waiting list and hopefully move out before temporary accommodation comes to an end. But it's possible, so local authorities, even if you are the most vulnerable person ever, local authorities won't have a long-term duty to house you. They still can if they want to. And there might be duties to you under the Care Act if you're exceptionally, kind of got some exceptional health issues. So that's, they're likely to be your options. Now, Jan Luber, interestingly, the author of that textbook, would say, if one local authority finds you intentionally homeless, then go to another one. And even if they refer you even if they refer you back, you've still got a few days potentially. And Jan Luber, I think, uses the reason potentially the second local authority might be more charitable or kind of nice to you than the first local authority. So that's sorry, go on, Shannon.
Yeah, I was just going to say, so I've seen a follow-up comment about kids and a wife. And I'm just wondering, obviously, so there's the other option is if you've got an intentional homelessness decision and you've got children, essentially the housing department will make their intentional homeless decision, but then they'll pass you over to social services, and then social services would house you. And I'm just wondering what your guys' experiences are, because I guess the other option is you could make a homeless application in the wife's name, and
Yeah.
as long as she wasn't, committed this crime alongside you, then she potentially wouldn't be intentionally homeless, and so you'd get the full housing duty from her. But would it be better to do that route, or better to go down the social services route?
So in my experience, the social services route is rough. When people have done it before, they have to go to the council with all their suitcases and their children and just refuse to leave. That's how I've seen it work. It's horrible. So although the social services have a duty, but it's in practice, and they'll stick you anywhere. They don't care. They'll specifically stick you outside of their area sometimes, I think, just so they don't have to continue. They can then transfer you to a different local authority, and then you have to worry about you anymore. So if it was me, I would definitely be, seeing if the wife was able to make the application. Now, the council, I know the council would then look at this word called acquiescence. And so what they'd be looking at is, with the wife, did she know about the crime? And what the council would probably say is, when you bought the house off your granddad, did you know that the money for it came from the proceeds of crime? And I would imagine, again, I would say that would potentially be enough for a council to argue, if they're right about it, to say that actually, although the wife might not have actually committed the crime, she acquiesced in that setup. So she knew when she bought the house that there was a chance that he could get convicted, and basically, so therefore the kind of the making a separate application wouldn't help. If you really want to kind of push the law to its limits, the dad could make an application, get 3 months worth of housing, and then on the day after they get evicted, or the day they get evicted, the wife could make an application and do the same thing, and get another 3 months. But it's not obviously a long-term plan. So I would say the best ray of hope there is that the wife makes a homeless application and she was not involved in that sequence of events that led to, to give you a couple of cases that give you an idea of acquiescence. There's a case, I think it's from the 80s, so it's kind of telling that the judge made this joke, but basically I think the guy had a gambling issue. He spent all the money, and didn't pay the rent. Told his wife that he was paying the rent, but then the bailiffs come knocking or whatever, and the wife, in evidence to say that she didn't know about it, she said, "Well, when I found out about it, I hit him so hard he fell off his chair." And as I say, this is 1980s judgment, so they were quite jovial about it all. But that was evidence that she was not. She was not in on it. But it's one of the few areas where the default position is in local authorities' favour. So the local authorities' default position would be to assume that you acquiesced unless you can prove that you didn't. Whereas most things, you're kind of, you get the benefit of the doubt. With acquiescence, you don't. So the wife would have to show, and it probably could be quite easy to show, because you probably have a lot of police information and stuff like that with the trial and all that sort of stuff. So the wife would probably be able to show, actually, I had no knowledge of this, or I had nothing to do with this kind of this sequence of events, and therefore I'm not intentionally homeless. She would be in priority need because of dependent children. So I think that's probably, I don't know, that'd be my kind of first way of dealing with it.
So there's a couple of follow-up questions there. So it says, did you address that? Should I tell the housing officer I'd like my wife to be the main person? I mean, like you said, I think I just wait and see what they say, and then you could always say the wife. I think it should be the wife who should say, I'd like to be the main. I'd like to make an application myself, actually, rather than if you say to them, can she be the main person? The response is likely to be, oh, you're just trying to get around it, aren't you? But if she makes the application, she's got her right. She's entitled to a written decision. But I hate to go on, but I still don't feel good about that being intentional homelessness anyway, because I've always assumed, and I may be wrong, that in order to be intentionally homeless, you have to lose a house or a home which you had at the time when you committed the act. It seems very hard to think that you could be intentionally homeless for a thing you did 11 years before you got the property. Because it's hard to see that there's a link between the two. But I take your point that they could get away with it because, like I say, it was a deliberate act, and because of that, you lost the accommodation, so no more questions. But
yeah, I remember. I mean, I'm not going to be able to remember the name of it. When I worked at Bedford Borough Council, and I was first finding out about all this stuff. I remember reading a case. So this was 11 years ago, so it might be out of date anyway. But there was a case where exactly that happened, where a guy committed a crime. After a couple of months, he moved in somewhere, and then the kind of police investigated and found him and convicted him, and he was found to be intentionally homeless. But as I say, whether there's been further developments on that, I don't know since. But I think that was the
yeah,
position of the argument. That
yeah,
judgment was, when you commit the crime, you knew there was a risk you'd lose your home from it. So it wasn't a kind of good faith kind of defence or anything like that. It was,
sure,
but
sure,
yeah, but on your point, Will, about kind of housing officers saying, oh, you're only saying that to get housed. They will say that, but just to any homeless person, you are entirely able to enjoy the rights you have under housing law. So you're absolutely allowed to play the game that suits you best, because that's the law's been carefully designed to be like this. You shouldn't be kind of looked down on for trying to get the best for you and your family with what you've got. So that's kind of my take on that sort of attitude you get from housing officers, but you probably will encounter it, and they'll probably try to resist it at first. So yeah, but yeah, complicated situation. So have we missed any? Shannon did that one. So, what would be suggestion on suitability review? Is that the one? Yeah. Yeah. So, what would be your suggestion on a suitability review if the 21-day deadline has been missed? Ask to extend the deadline with judicial review if refused, or ask them to reassess suitability on basis of change of circumstances. So, I guess just the basics. So, if a council makes a negative decision, except for a couple of exceptions, you've got a right to review, but you've got to submit the review within 21 days of receiving the letter. And I'll tell this story probably a load, I'm sorry, but I remember back 2015, when I was kind of started off with Just Us, 2014 maybe actually, the council had issued a decision and it has this date on it, and the person received it, and the date was already out of date. It was already kind of over the 21 days. And the council said, oh no, we definitely sent it. The person definitely received it. But then you look at the postal mark on the envelope from the council's internal postage department, it showed that it hadn't been sent out for another week or two. I can't remember how many it was. So I was able to kind of scan the copy of the envelope back to him and say, you didn't issue this on that date, you're lying. And it did the trick. So yeah, so you've got this 21-day deadline. If it comes to, I mean, it's quite difficult to ask for an out of time review unless you've got a good reason. So it might be, let's say for example, you've got a learning difficulty and you struggle to understand it. That'd be a good reason for it. But even though someone in that situation is probably going through an awful lot, if for an ordinary, healthy and robust person, and I use that language because it fits in with what the law says, you'd be expected to make that review request within the 21 days, unless, as I say, unless something very unusual happened. But if the accommodation has become unsuitable because of a change of circumstances, I would assume you'd be able to reapproach the issue. Basically, I don't know if you guys have got any experience
definitely,
of that. Yeah. Okay. So yeah.
My view and my experience is that the 21-day time limit doesn't work with suitability reviews because it wasn't designed for suitability. It's designed for a whether we owe you a duty decision. You've got 21 days from when you get the decision. You could move into a place today and it might take you a month to realize that there's damp coming through the ceiling, or the next door neighbor is harassing you or something like that. But let's just, so you could really say, I'd like you to consider this anytime. Now, if they say no, the question has sort of got on to the next step, because the default position for challenging any local authority decision is judicial review. Now, if you went straight for a judicial review when you could be going for a 202 review, they would say, no, you've got an alternative remedy. You can't come to the High Court. But if in this case, you could say, well, I asked for a review, but they wouldn't carry one out. And there is no 21-day time limit with judicial review. There's arguably a 3-month deadline from the date of a decision. But if you say to them, please, can you treat my accommodation as unsuitable? And they say no, that's the decision. So the 3 months runs from that. And then a little bonus extra point. you can use is that if they refuse to consider whether your accommodation is unsuitable, go for it and carry out a review. Go for a review, a judicial review of that, but also make a fresh homelessness application, because you're saying that you've got accommodation which is not reasonable for you to continue to occupy. And that brings you within the definition of a homeless person. So you can say to them, either you can give me alternative accommodation pursuant to my first application, but if you're refusing to do that, then give it to me pursuant to my new application. And you're under a mandatory duty under section 188 if you're in priority need. So if you use the combination of those things, I've never had a council say no to a review out of time, because they know that they're stuffed if they do that, because it's, in fact, agreeing to carry out a review will give them plenty of time, because they've got 8 weeks to carry out the review, and then another 3 months if you go for an appeal, if you're lucky. Whereas if they say no, I could be in the High Court quite within 28 days, usually, because you just send them a pre-action letter and then go to court. So but my suggestion would be threaten them with judicial review and make a fresh application, and they'll back down, unless they're very foolish.
That's cool. That went over my head, Will. But I'd listen, if I was in the audience,
Sorry.
no, it's cool. I'd go back over and just, because there was a lot of, yeah, this is completely outside my normal sphere of experience.
It's
it's
something I
interesting.
come up with a lot, because you think, you know, I'd say quite a big percentage of my caseload is people wanting this, and then this relationship between review or judicial review, section 188, section 193. I mean, I spend a lot of time agonizing and sort of getting headaches over that. So sorry if I was sort of free associating there.
I'm not. Yeah, no, I'm not. It's just the law. The law's complicated, basically, and the processes are. I mean, it's almost like they've been designed to be difficult to navigate. Cool. So, and you just answered that second part of that as well, Will. So, how likely the councils would accept change of circumstances or new info? I mean, I guess the key thing is the new information's got to be more than trivial. So it's, you know, it's got to be a real thing.
And oh no, it's not the same questioner. You don't need any supporting documents for a section 202 review. I mean, you may need to prove something in the course of it, but in order to request a review, you don't have to say, here's my form ZX51, or here's my proof of entitlement to make a review. You just say, I would like you to carry out a review pursuant to section 202 of the Housing Act 1996, and then they've got 56 days to do it.
And something just to throw in here, because we often do when we get this question. So if you've been in section 188 interim accommodation because they think you're in priority needs, and then they find out that you're not in priority need, or they make a decision you're not in priority need, you can ask for a review of that decision. But if you want to continue having temporary accommodation, you need to specifically ask for temporary accommodation. It's really annoying. You've actually got to almost say the words, can I be housed whilst this review is taking place? And you've also got to provide some new information, or, you know, or information that's more than trivial that would that might affect the decision. So I've had a review officers once try and say that they wouldn't accept the review request because there was no chance of it kind of overturning the review. But we overturned the review, so that was nonsense. So I think, yeah, that's or overturn the decision, I should say. So I think you might have, it's not something I've seen a lot, but you might have house or review officers try and be difficult and say that they're not going to do it for some reason, but just persist and say, no, it's a fair request. On that question, I get, yeah, in terms of supporting documents, it all depends on what argument you're making. So if you're making an argument that you're in priority need, then yes, supporting documents from any health professionals or anything else, anyone else involved from that point of view, is going to be what you need. If it's a review request about not being homeless because you can afford the rent, then, you know, more financial information, more financial documents, and so on. So it just kind of depends on what the argument that you're having to go against is. So, okay, cool. Yeah, I think that question about the review, yeah, we're now tied that off. That's good. we're coming to 8:30, guys. If you need to go, then call. I've got a few questions that have come in through the week that I just want to make sure I cover. So if you guys need to dash off, whatever, then feel free, whatever. So this question we'll definitely do this question. So we've got a family of 4 currently pregnant. So yeah, mum's currently pregnant. First made homeless in 2020 and given a private rented sector offer in order to end the relief duty. We had no choice but to accept and put in a suitability review. The decision was overturned and we were moved to another private accommodation, this time in our own area. We were never given a bidding number, so I assume we weren't eligible. After emails to the council, we now have a bidding number. My question is there a way to get a main housing duty instead, as we're currently facing eviction again? I have asked the council to move us as the house is full of black mold and environmental health, blah, blah, blah. So there's more to it, but that's the kind of bit that we've covered some of the other elements already today. But so let's just break this down. So again, it's just worth going into a bit of detail just so to make sense of these questions. So you make a homeless application and you're actually homeless, so you're not threatened with homelessness, you are actually homeless. The relief duty kicks in as soon as the council's satisfied that you are homeless and you are eligible for assistance. In that relief period, the council can do 2 things. Well, they can do a lot of things, but they've got 2 avenues to try and get rid of you. One is to give you a final accommodation offer, and the other is to give a final Part 6 offer. And the final accommodation offer is basically an offer of an assured short hold tenancy in the private rented sector. Now, for this situation, that family is going to be owed the main housing duty because they've got dependent children, and assuming they're not intentionally homeless. So although this person was probably told they had no choice to accept it, they actually did have a choice, because what they could have done is said, no, we're not going to accept that final accommodation offer, and then see what they get from the main duty. Now, annoyingly, and I didn't know this until a year ago, so I actually did a video about this and got it wrong, so I did take it down again. But basically, if someone who's going to be owed the main housing duty, and you know that because they're automatically in priority need because of children or whatever, and you know they're not intentionally homeless, so ordinarily, or before the 2017 Act came in, the Homelessness Reduction Act, they would get the main housing duty. Now, the way this works now is with the relief duty, the council can give you a final accommodation offer or a final Part 6 offer, which is an offer of social housing that you get no choice about. You can turn it down, but you wouldn't then get the main housing duty. What you then get is like a reduced housing duty, which is the same as what was given before. But if it was me and that initial offer of accommodation was just not suitable, I would potentially turn it down in that situation and wait for the final, wait for the main, wait for that Section 184 decision to be issued after the relief duty. Apologise, this might sound like gobbledygook because it's really complicated for no good reason, but it is. So the worst that would happen then is the council offer the same accommodation again and say, no, we're still going to give you this one. And at that point, you do have to accept it. But hats off to this family for putting a review request of the suitability and winning. So that's the kind of that I just wanted to kind of draw that out of that question. So then now this is where I was slightly confused. They've been put in another private accommodation, this time in our area, but now they've been given a bidding number which says to me they're actually in temporary accommodation. I guess technically you could have a bidding number whilst in private, but it's very unlikely. I think very unlikely you get a good banding anyway. So that I'm not quite sure how that works in practice. What's happening there? The question is, so they're going to be made homeless again anyway. So yes, they can make a fresh homeless application as they did before, but unfortunately, there's no way of getting around this final accommodation offer business. The council can do it. I spoke to some housing officers and they say we don't bother because all we know is in another 6 months the family's going to be coming back to us. So some councils don't do this. They just say they stick with the final or the main housing duty. But yeah, you can make a fresh application and effectively you go back to square one, except that you've been bidding for some time, so you would have presumably worked your way up the list a little bit with priority. But yeah, I'm not sure if I've really kind of given a very clear or helpful exploration of that, but the short answer is yes, you can make a fresh homeless application when you become homeless again, and in one sense that kind of deals with those other kind of complications, and you just essentially start from scratch. And then the final bit is, that they've got some mobility issues, and they're asking, is it worth getting a care needs assessment in order to evidence that they're in higher priority? The answer is yes, definitely. If you've got a medical issue, you want to have as much supporting evidence as you can to demonstrate not only what the issue is, but specifically, whether that means you can't get up and down stairs, and it's often an OT that's going to actually give that assessment rather than a GP. Sometimes it's going to be obvious. Sometimes someone's in a wheelchair, they're not be able to get upstairs, but any evidence you get is going to help you out, because it's going to help make sure you get the best available options for your conditions. So yeah, I'm not sure if that made any sense to anyone there, but yeah, if you followed it, well done. And that just kind of gives you a glimpse into this final accommodation offer and final Part 6 offer that comes under the relief duty. That, as I say, it seems to me to be a really bad move from the lawmakers to have done it, but is what it is. So yeah, the other questions that came in through the week, they can wait. They're not they're not directly time sensitive. So there's a questions coming from the live stream, which I think we're going to make our last one for the night, unless there's any kind of real quick questions that come in. So someone, their partner, they and their partner were making friendly payments to cover cost of utilities whilst sofa surfing. Now the friend is now asking rent that we can't afford. We have a week to pack. What to do to get temporary accommodation ASAP? So the key, yeah, so you make a homeless application, as we've kind of said already tonight, via email to your local council all the time, and lay out as much information as you can that you think is going to be relevant. The question here is going to be that, are you in priority need? And is there any reason to think you might be in priority need? If there is no reason to think that you might be in priority need, the council will not owe you any accommodation duties. So there's no mention of children here. This could be just a couple without children. So unless there are vulnerabilities which are kind of relevant to the one or both of the members of the household, then the council isn't going to be much help, except that, I guess, technically speaking, you might be sofa surfing because your house burnt down, or you might be sofa surfing because you were fleeing abuse or something before, in which case, you might actually be in priority through one of those kind of categories, but it's probably less likely. So that would be what I'd be doing, is actually, before you make the homeless application, as in, within the next 24 hours, work, read up a little bit about priority need. There's some useful videos on this channel. So Sarah Steiner did one which says, I think it's called A Judge Explains Priority Need or something like that. So look for that video. There's a 30-minute video about priority needs, about vulnerability. But that's what I'd be looking at. Otherwise, the council won't owe you a housing duty, and that means you need to be looking at supported accommodation, those kind of really sort of ropey options that people have. And there's a particular issue here that if you're a couple and you want to live together, then actually that's not quite as easy said as is done, or is done as it's said, or whatever. So so the person did this follow-up comment: both parties have epilepsy. Okay, you're very much in the ballpark of being vulnerable. There is certainly reason to believe you might be vulnerable if you have epilepsy. Although again, you're going to have some council officers who deny that and say, oh, that you're fine. So yeah, what you want to do is, in an ideal world, is to get a medical opinion of, you could ask your doctor, what's my diagnosis? What's going to happen to my epilepsy if I was to become homeless, and what harm could result? I'd imagine you get some pretty clear answers back from a GP if you ask those questions. And if you explain to your GP, look, I'm going to be homeless in 7 days, can you help me out urgently? Certainly some GPs will be like, yeah, sure, we'll help you out. We'll get you a letter. So yeah, then there's also mention there about kind of discrimination and basically just traumatic experiences, which again, they're relevant to vulnerability, but they could also mean that you actually, when you initially became homeless, you were actually fleeing abuse, which would mean that, fleeing domestic abuse, potentially, depending on the kind of ages and stuff like that happen there that relate to the comment. But yeah, so there's that kind of thing as well. So I think if it was me, I'd be just spending a day just reading up on the law, trying to find out what's relevant. and then make the homeless application now, and then and tell them we have only got 7 days before we get kicked out, or we got 6 days now, or whatever. And although you shouldn't have to, you might as well get a letter from your friend and saying that they're going to kick you out, because it just helps. So yeah, have I missed anything out there, guys? Or kind of?
Yeah, I've got one suggestion that we may have missed, is that in the original question it refers to making friendly payments and then says they're asking for a rent, which we can't afford. It doesn't mention sofa surfing. Now, it could be that, and it says the friend has accommodated them. If the friend has given them exclusive occupation of a property, for instance, the friend lives in property 1 and they've given them property 2, or even part of property 1 in return for money, then arguably they have a tenancy and they have statutory protection. So the friend, I mean, calling it that, somebody's going to kick you out in 7 days. Well, they may have been a good friend in the past. It's not for me to judge that, but they would be very annoyed at this. But you could say to them, sorry, we're not going anywhere. We're your tenants. And I've had this before. I had a case where a family let a friend of the daughters come and live in their house, and she paid a bit. She had her own room, and let's just say it came within the statutory definition of a tenancy, and they tried to kick her out, and they got taken to court for unlawful eviction. And the council, this is going back a few years when council still had sort of enforcement officers who stopped people getting evicted, they prosecuted. And so if they go to the council and just raise this, the council may get onto the friend and say, you do realise you can't kick them out in 7 days. And if you do, we'll prosecute you. So that's the thought. It might buy you a bit more time. But other than that, I can't think you've missed anything, Mike.
Well, so I mean, it's a good point in terms of, so sometimes when you're managing those relationships, or even if you're just managing a dodgy landlord, full stop, if you go to a council and the council says do not leave, that's going to be an illegal eviction. You can kind of then take that back to the friend or the dodgy landlord and say, look, the council's telling me specifically I shouldn't leave, and if I do, the council will also tell you if you do leave, you'll be intentionally homeless. So you can say that and say, well, look, I'm not trying to be difficult here. That's the advice I've been getting.
Yeah.
That's the legal advice I've had from the council. What do you expect me to do? And so it kind of just helps manage that conversation, if nothing else, because I imagine it'd be quite a tricky one to navigate.
It might be worth getting the council to actually contact the friend as well and say, hello, it's the council here. We hear you're thinking about evicting somebody, but we'd advise against it.
Yeah. And in one sense, if that was the case, then you would presumably be able to claim universal credit for the rent, if you haven't, if that person hasn't already.
You'd probably have some struggle because they'd say, oh, we want a tenancy agreement and, blah, blah, blah. But if you appealed it, eventually you would probably get some rent, because if you're liable to pay rent, it doesn't sound like, I mean, it may be argued that it isn't really, because if they're saying it just covers the cost of utilities, but then again, if you're paying something, you never said the rent had to be a high rent, and a rent is just money in return for exclusive occupation. So it's worth having a go.
Yeah. Okay. Cool. There's no more questions come. Oh yeah, go on, Will. Yeah.
Can I just make one other point? And I'm not the person who asked the question about. I think it was suitability. I'm not going to go back about suitability reviews, but this is the subject. The person's come back with a question saying, if they refuse, is it likely to be irrational? And I'm just going to leave it at this to say that irrational is a sort of rabbit hole that, in terms of housing law and public law, the meaning of that word, we could have a whole session on that, because it comes down to challenging decisions on the basis that they're irrational. And in a nutshell, it means a decision based on irrelevant matters, or not taking into account relevant matters. So if I said, I'm not going to house you because I don't know, because Charlie Watts from Rolling Stones died 2 years ago or something, that's irrelevant. It's irrational. And if I said, I'm not going to house you because you're not homeless, I've failed to take into account the fact you're homeless. But it goes way back, and it's a really interesting subject. But I just say, the answer to the question, if they refuse a review out of time, that wouldn't actually be irrational. It would be something you could challenge in the way I said before, but just look out, if anyone's reading homelessness law stuff, you'll see that word irrational cropping up, and it's quite confusing.
I guess it's I mean, yeah, now you've said it, it's an interesting point in terms of effectively local authorities have this kind of like this bandwidth they can work between being really, kind of for you and being really against you. And yeah, there's so you might get two different responses from two different officers, but they're both acting lawfully, although one's been less helpful. But as Will was saying, there's actually the point where you depart from that bandwidth altogether, where there's a term Wednesday unreasonable come, where basically no
That's right,
reasonable
Wednesday
person
unreasonable.
acting reasonably could make this decision.
And that was a case from 1948, which I could go into it in great detail, but it was all about whether children could go to the cinema on a Saturday afternoon, and whether the local authority had the power to stop them. But the ironic thing is that if that case was decided today, it would have nobody in their right mind would have made the same decision. But it's a really interesting example of how the law changes and what it means. But I'd be happy to talk about that another time.
Yeah, it's in. I mean, as you say, it actually comes into play in a lot of different situations. I've certainly had a lot of complaints like not upheld because although I think it was a stupid decision, it wasn't irrational. It wasn't technically irrational. So yeah, but it's still frustrating. There's just a question that's come in there, which again, guys, if you need to head off, cool, I'll stick around and answer it. So if a disabled person is basically making a housing application, what are the points the doctor needs to raise? So this is it all depends on what is going to be the pertinent issues. So housing application, homeless application are two different things, although they interact with each other. So if it was a housing application, you'd want whatever you need to know to work out if you get medical priority on the banding system, and also what type of accommodation you needed if you've got a disability, or if you were, for example, if you were a wheelchair user, I keep using that example, you would need at the very least a stair lift, if not having no stairs at all, level access shower, all that sort of thing. So it needs to be kind of relevant to that. If you think the issue you're going to have is arguing that you're in priority need it under the Part 7 homeless application route, then you're going to need to have information about what your issues are and effectively what's going to happen to them if you were to become homeless. Again, yeah, I mentioned it already. Really good video on this channel by Sarah Steinard. A judge explains priority needs. So watch that. She covers everything you need to know basically about it. And then again, it could be medical issues become relevant to intentional homelessness if it's mental capacity issues, or it could become relevant to homelessness itself if it's mobility issues or something that's making it unreasonable to continue to occupy. I mean, if you want to push it all the way, it could technically be local connection in terms of you might have a medical issue which you can only get treatment for in one particular hospital in the country. Not that I've ever seen that, but that's a technical possibility. So it kind of, I'm not trying to be unhelpful, but it just depends on what argument you want to make to the council, and it's going to be related specifically. It's no good just getting a doctor's letter that says, yeah, Joe Bloggs is a lovely bloke, please house him. That's meaningless. You want a letter which basically goes into detail about your medical issues in relation to that particular priority needs, suitability of accommodation, and so on. So yeah, we're going to call it a night, guys. Please do subscribe to the channel, like the video, blah blah blah. Thanks very much for sticking around, asking some really good questions tonight. Keep the questions coming in on the YouTube comment section. Doesn't matter what video you post on, I'll get notified at some point. It needs to be a question. If someone says I need help, you won't get an answer for that. We just don't have capacity to actually help people, one-to-one or whatever. But yeah, as I say, hopefully that's all useful, and we'll see you next week. You guys here next week? Yeah, cool. Should be a trio next week then. So yeah, hope you guys have a good week out there.